military chaplains, in that kind of a context, we're really worried about free exercise. We've taken people and put them in the military and separated them from their ordinary lives, and we don't want to deprive them of access to religious opportunities. So we're willing to pay for and make available chaplains in those circumstances. But in the case of public schools, we're truly worried about establishment. We're not worried about free exercise so much there. And the idea of providing religious figures and paying them to work, if you will, in the public schools, we're worried about the government sponsoring religious activities among children. We're not so much worried that the children won't have enough opportunities to express their own religious beliefs. So the context is often quite important here, and there can be an underlying tension between the two clauses that sometimes comes out. Let's first start with the Establishment Clause. The First Amendment says that we shouldn't have any laws respecting the establishment of religion, and this protection applies to the states through the Due Process Clause of the 14th Amendment. Now, the Establishment Clause prohibits not just the creation of a state religion or having a state church, something like that. Of course you can't do that. But it's also a requirement that prohibits the government from favoring religion, favoring one religion over another, or favoring the religious over the non-religious. Basically, the government's supposed to remain neutral respecting religion, neither aiding one religion or all religions, or preferring one religion over the other, or anything like that. Now, it's impossible, really, for the government not to involve itself in some way with religious entities, given their proliferation in society. And given the fact that the government regulates so extensively, the government affects almost everything we do. And so we can't have a perfect separation of government activity and religious activity, probably even if we wanted to. In our society, there's just too much religious activity, too much religious pluralism, and too much government involvement with everything that we do to permit that. So it's a struggle, but we have tried to develop some rules to maintain a kind of neutrality. Now, for a long time, the court used a three-part test that came out of a case called Lemon versus Kurtzman, and it's called the Lemon test. And it does explain a lot of the court's prior cases, but I have to tell you that now, even though I'm going to mention this test a little bit, the court has become very grumpy about this test. It really doesn't like this test. It's criticizing it all the time. And each term where there's a religion case, Supreme Court observers say, well, this Lemon test is going to go down the tubes this term, but it never seems to happen. The court has never overruled the test, and I think the court is a little bit disoriented because it's not quite sure what to adopt in its place. Some justices have taken the position that all intersections with religion are okay so long as the government's not coercing anyone to believe anything, not to believe anything, or to believe anything, or to support or not support religion. There does seem to be a majority that is evolving around something like an endorsement test, prohibiting the government from taking actions that appear to endorse religious activities, but we're not quite there yet. In any event, under the Lemon test, there will be an establishment, and hence a basis for striking down a law, if you have any of the following three factors. First, if the law has a religious purpose to it, that is, if it's an attempt to aid religion, that's what it's all about, it will be struck down. Second, even if the law has a secular purpose, if its overriding or primary effect is to aid religion, then also it would be struck down. Well, finally, the court has said, if the operation of the government's regulation or law entangles the government too excessively with religious activity, they get all bound up together, acting and operating together, then it would also be struck down as an establishment violation. Now, establishment cases and issues tend to arise in three areas. First, generalized government benefits that are furnished and which are also furnished to religious groups. Second, government aid to religious schools. And finally, the introduction of religious ideology, typically school prayer, into public schools. Now, with respect to generalized government benefits, the rule is pretty much as follows. The government can aid religious groups in a benign, everyday way, so long as it doesn't go too far. So, for example, in the furnishing of generalized government benefits like water and fire, and the fact that there are some religious references in our everyday life, like on the money it says, "In God we trust," or even having legislative sessions opened with a prayer, because historically that's been accepted, these kinds of aid or assistance or recognition of religion are thought to be benign or historically accepted, or generally they provide government benefits that really are not specially tailored or a special big deal for religions. You know, they're neutral. You're going to provide fire service, so you provide it also if the church is burning down. But you don't go crazy. The government's efforts to assist religions can go too far, particularly if you have a case, and be on the lookout for this, where the religious groups are getting benefits not generally available to the public. These the court tends to strike down. For example, there was a case where a particular community had a law that allowed churches to veto the issuance of liquor licenses if the liquor store would be located too close to the church. And in another case, the court struck down a scheme whereby New York gave a special religious community control over government decision-making in the schools that operated there. Another law, for example, exempted religious publications only, not other publications, just religious publications, from sales and use taxes. This was a law that gave the religious community a special benefit. All of these laws have been struck down. A particularly hot area of figuring out when the state has gone too far involves the so-called crutch cases, or the display of religious symbols. And the court's way of dealing with this is most recently illustrated by two cases that came out of Pennsylvania. In one case, a display was struck down, and in the other case, it was upheld. In the case where the display was upheld, this was a display of a menorah and a Christmas tree on the outside of a government building, and sprinkled around this display were other secular items. The court upheld that. But it struck down a crutch that was located on the inside of a government building. And by that I mean a depiction of the birth of Jesus. And that was the only display. And it was located inside the building in an area of special prominence. It was on a grand staircase with lights on it and all the rest of it. And there were no other secular items around. It was, really that. Boom. Well, in that case, the key was, for a majority of the court, in one fashion or another, and Justice O'Connor has been leading the way here, is to ask whether the display appeared to a reasonable observer to involve in government endorsement of religious themes. If it did, then it would be struck down. On the other hand, if it merely acknowledged the secular aspects of the holidays and didn't appear to endorse religious messages as such, then that would be okay. Now, some have referred to this, sort of as the wise guys, as the so-called reindeer rule. Apparently, if you sprinkle around enough secular items like reindeer, then your display can survive. Now, the second area where establishment issues come up is where there's government aid to religious schools. And here again, we can offer something of a general rule. If the primary effect is to promote religion, or if you have programs where the government has to operate closely in concert with and on the property of the religious schools, the court's going to strike things like that down. On the other hand, if the aid that's furnished can be used without monitoring, and if it's generally available to others for secular educational purposes, the fact that religious schools also get the benefit will not be determinative. These kinds of things can be upheld. A good example of this contrast are two cases. In one case, the state gave everybody a tax deduction for educational expenses. And everybody got it, including parents of students in religious schools. And that was upheld. But the court struck down another government program that gave a system of tax credits only to parents sending their kids to religious schools. They were the only ones who got this deduction. That was too much. Now, the court has looked at a whole variety of forms of aid to religious schools, and as I said, pretty much it's upheld those kinds of aid that are generally available for educational purposes and pretty much struck down those that involve too much of a direct advancement of the religious aspect and too much entanglement between church and state. The final area is the introduction of religious ideas